Hello, everyone, and welcome to our webinar, Working with Privacy Agents. By way of background, Ethos Privacy partners with clients on their privacy programs, striking the right balance between privacy goals and privacy needs. We bridge the gap between current state and optimal state, given the pace and complexity of privacy legislation around the globe. Today's webinar features 4 panelists who will present different points of view, and then we'll launch into questions and discussion. The session is being recorded and will be available later. Please add your questions to the Q&A section or add them to the chat. Panelists will be adding links to extra materials in the chat. Now I have the pleasure of introducing Jeff Jokish. Jeff is a data privacy researcher and the CEO of Privacy Plan. He focuses on creating and analyzing data sets in the privacy space.
As privacy pros, you all likely know that fair information practice principles originated back in the 1970s, in part from an HEW report in 1973. This report really focused on 4 basic rules: transparency, access, use limitation, and the ability to edit wrong information. Our data subject access request focuses came from these particular words. There must be a way for an individual to find out what information about him or her is in a record and how it is used. Pretty simple, right? The FTC has focused on 5 core FIPPs that you can see here, but the intent is very similar. Right? Let's go to the next slide, Karen. Fair information principles are manifest in legislation that impacts our data privacy, and even legislation that predates these principles. The list you see in front of you is US-centric, and I've tossed out a few that are on the periphery, so it's incomplete, but it gives you an idea of how important data subject access rights are, and perhaps also how they've been under the radar. You don't really hear a lot about, you didn't really hear a lot about them until the last few years. Consumers really even rarely realize that they have these rights. As an example, I'd wager that only a few parents in 100 know that they have FERPA rights and realize how much data they can get from schools about their children simply for the asking. We have many laws that give us rights to access our data, some old, some quite new. Why are DSARs and privacy agents now a big issue? I'll tell you why, right? The proliferation of our personal data has given thousands of organizations access to this personal information about us. And accessing it may be a right, but is it a right that we can feasibly implement? How much effort would it take to get my data from the 500 data brokers that are registered in California and another 250 major brands that I interact with? Are consumers using DSAR? Are consumers using these DSAR processes? Let's find out more about these issues from our speakers. First up, we have Ben Moskowitz of Consumer Reports. We all know Consumer Reports, and Ben is the founding director of the Consumer Reports Digital Lab, where he leads digital consumer protection and innovation strategies. Welcome, Ben.
Hey, everybody. Pleasure to be here today. I'm going to go ahead and share my screen and just build a little bit on what you just heard. Am I coming through okay? Can I get a thumbs up?
You're good.
Yep. Great. As Jeff said, I'm heading up the Digital Lab at Consumer Reports. This is a new initiative, and it builds on the work that we've been doing to evaluate the privacy and security of products and services for many years. Now we're starting to look at what are solutions or what are sort of pro-consumer innovations that we can support. And we're very interested in data rights and authorized agents as being an area that could have great benefits for consumers. So I'm going to talk a little bit about the model of authorized agents, some of the work that we've done at Consumer Reports to understand the development of the ecosystem, and some of what we think is necessary to make this ecosystem workable. So we try to boil it down and keep it simple. You know, the way we see it, CCPA, which is sort of our lodestar in California for the US, has these 3 rights, if you want to keep it simple. The consumer ought to be able to get a copy of the data that the controller has collected, delete the data, and in the California context, ask that it not be sold. As Jeff said, though, having the right is one thing, having the right that you can exercise is another. We did a study last year in which we recruited 542 volunteers to make do not sell requests to data brokers listed in the California Data Broker Registry. And we found some things that made us worry that even before you have authorized agents in the mix, just asking people to go and exercise their rights is a tough proposition. What we did is for each site, we had 3 testers go and just try to opt out of the sale of their data on their own without really any instruction. And almost half the time, one of the 3 testers was just totally unable to find a do not sell link. About 1/8 of the time, the do not sell process that was established just wouldn't work, or it would be overly burdensome. Like you'd have to submit some documentation, which is actually against the statute. About half the time, consumers were either left waiting or just unsure that the request was processed. And a little over half of people were either somewhat or very dissatisfied with opting out. So I think that kind of tells the story that, one thing to have this right, whether it's a useful right or right you can feasibly exercise is sort of the question. And so even highly motivated consumers who know about this stuff, it's a lot to ask them to go and step through a procedure for each and every company where they might want to exercise their right. That's why the agent model is so fascinating. It's the kind of public interest innovation that we need, I think. It's almost akin to the creation of like the do not call list. Before the do not call registry, you just had to kind of deal with spam and getting called at all hours of the night. And, public policy came together and defined a solution. It was part regulatory, part technical, and now we got a do not call list. I think that authorized agent as a concept has that kind of potential. It has the kind of potential to be a solution that any consumer of any age, of any knowledge could find one and sign up and have an easier time exercising their rights. We think that authorized agents conceptually aren't just about privacy. There's a lot of things that authorized agents could feasibly do in the future. So we are a consumer protection organization. We do a lot of investigative journalism. You can imagine a tool like an authorized agent making a journalist's job easier. When CCPA came into effect, you started seeing stories where journalists would issue requests and then write what they found. The DSAR request almost becomes like a FOIA request. And so that's really interesting. You're seeing examples of collectivizing consumers' data rights and using them for organizing. There's a great organization in Europe called Workers Info Exchange. They are essentially unionizing Uber and Lyft and delivery drivers and sending data subject access requests to try to understand how workers are treated and try to get the employment data that should belong to the worker. Now, this is interesting because it's using a consumer data right for like a labor organizing sort of purpose. But the point here is that there's lots of potentially interesting applications of these data rights and of authorized agents to help make them workable. In fact, we at Consumer Reports are working on an experimental authorized agent service, sort of in incubation right now. It's not something that someone can sign up for just yet, but later in the year, we're hoping to have an experimental service that will make exercising these data rights really easy and help put things in context for consumers. We think that it's not the case that consumers should spam data rights requests to hundreds of companies without a whole lot of intent. So what we're interested in are very intentional and informed requests that help the consumer with the job to be done. But we'll have more to share about our own R&D process here on a product. I wanted to share that because we're doing a lot of research that's dual or triple use. So we're doing research to understand the state of the ecosystem, to advise regulators on how they could make these rights more useful for consumers, and to inform how an organization like Consumer Reports, which is a nonprofit, might offer a service like this that would be useful to consumers. So I just wanted to be clear about that. We've run small pilots in which we have become an authorized agent. So the first one we did was in October of last year. We registered 124 volunteers. They signed a permission letter. And then we sent do not sell requests to 21 companies, a mix of different industries. And each company received 10 requests. So very small, very scoped experiment. The reason we chose do not sell requests is that statutorily, they're the simplest. They don't require the agent to have secured a power of attorney. They don't require the company to verify the identity of the requester, unlike the other kinds of requests. So we said, let's start simple and let's see what the state of play is when we become an authorized agent and help consumers exercise their rights. What we found is that, unsurprisingly, the ecosystem still has a way to go. The good news is that most companies made it possible for agents to submit the requests, which they're obligated to do under the statute. A little bit more than half acknowledge that the requests were relevant to their business. That's going to be an issue for these things to be feasible. 9 of the 21 companies processed at least one agent request. And we think, according to our definition of what would be appropriate, only one company of the 21 processed the agent requests appropriately. And by appropriately, we mean simple things like inform us that the request was successful. Technically, they only need to inform you if the request was denied, but they don't need to inform you if the request was successful. So if you have a false positive where you assumed that the request was processed because you didn't hear anything, it might actually be that the company ignored the request. So lots of issues that show that the ecosystem still has a ways to go. Of the companies who responded to the requests, the average time to respond was 7 days. Through this, we did a lot of work, which is similar to the work that Craig has done and which he'll talk about, to try to understand the consistency between different companies and how they handle authorized agent requests. So is there a functional and defined workflow? Do they have to get the consumer involved? Did they respond? How many business days to process? Was a provider, like a middleware provider, involved? And did they confirm the request? So we're building some knowledge of how these workflows work. And by default, just because of where we are today in the world, we're sending email requests. We're sending letters that explain the authority we're invoking, a copy of our certificate of good standing in California, some information about the consumer in question, and the signed permission letter from the consumer. So by default, we're doing all of this by email. It's a little bit of a slog. It's a little bit laborious. And what we found is that a lot of companies are unaware of their obligations to process these requests. So this is all documented in a report that you can read if you're so interested. And what we find is, okay, there's a couple fail states, and then there's a handful of success states. So, in the happy path, it's really simple. We issue the request is fulfilled, we get a confirmation, we tell the consumer, wonderful. That's what we hope to see. In practice, the company might not respond, so we will have to follow up, and they will either confirm that they didn't or they won't respond. Right, and we'll try to keep track of this kind of thing and escalate it. In fact, they don't need to respond if the request was fulfilled. We think that that's a gap, in the rules that should be addressed. But this is one pathway. Another pathway, we send the request. The company asks for additional documents. Now, in the case of a do not sell request, those additional documents are not needed. They're not, in fact, allowed. And so either we'll ask the company to process the request anyway, and they'll confirm, or they won't, and we'll have to report it. Fraudulence, the company might claim that we are not actually authorized, and so that might be something we need to confirm. Agent verification, and so on and so on. DSAR in the loop. That's for do not sell requests. Those should be the easy ones. When you get to access and deletion, you've got additional challenges because, of course, you need to make sure that the agent is trustworthy, and you need to make sure that the agent is authorized, and you need to make sure the consumer is who they say they are. So this is all kind of a gray area. Every company is sort of expected to implement its own approach to this. And so the conclusion that we draw is that the regulatory framework in CCPA doesn't yet support the needs of consumers and their agents. It gives companies leeway to establish procedures, which is good because they know their business best. But it's also bad because it creates the potential for loopholes and ways for companies to slow roll agent requests. And so we think that there's just too much gray area here. And one consequence of the gray area too, I'm sure you've all seen if you're processing these requests on the company side, agents like Privacy Bee and mine and others are beginning to create their own procedures and their own solutions. They may offer a portal where they're asking you to communicate to them through the portal as opposed to email. The intent there is good. The intent is to create some machine readability and create some automation, but it's not good in the sense that you don't want every agent to define its own process, for every company to define their own process, and for them never to meet in the middle. That's not a recipe for having a set of rights that consumers can meaningfully exercise. And just, I want to close out here with a proposal to kind of give you a sense of where we think things need to head. What you of course want is for consumers, companies, and their respective agents to all be involved in processing these things in a timely manner with minimal effort, right? We don't want friction. We don't want a lot more cost and time. It's in everyone's interest to streamline this a little bit and to get away from the improvisatory nature of how things are currently working. So we are interested at CR in developing a specification or a protocol in an open and voluntary basis that would basically detail how these transactions should work. And this is probably a bit too small for you on the screen here, but on the left-hand side, you've got a swim lane diagram. Sort of describes the transactions that need to take place between the consumer, the agent, and the company, possibly with a DSAR provider in the loop. And we think that if we can really hone in on a set of best practices and define them very clearly, we might be able to bring different stakeholders together to make this all work a little bit more smoothly. And we think that the benefits of that are not just on the consumer side, they ought to be on the company side as well. This ought to help clarify and streamline for the DSAR providers, and then secondarily for the companies. And implementing this kind of protocol or specification ought to give a rebuttable presumption that the company is in compliance with the CCPA's authorized agent provisions, and hopefully, future state privacy laws to be defined. So in conclusion, I just want to say, this is a very early, and I think it's fair to say immature ecosystem. But when we talk to consumers, we hear that there's a lot of demand for this kind of thing and to make it simple. And we think that everyone in this ecosystem has a role to play in coming together to make it workable, to honor consumers' intents, and to do it in a way that doesn't open up more risk, more cost, more time. So very keen on continuing this discussion. Look forward to hearing from the rest of the panelists, and I'll hand it back to my colleagues here.
Ben, thank you for that, that wonderful presentation. A lot of insight there. I think we've got probably a lot of questions, one in the Q&A already, but let's hold off for that till the end here. Next up, we've got Grant Barrett, Privacy Director for Ethos. Grant actually brings a really unique regulatory compliance and enforcement perspective to us. He is a former California Superior Court judge, which is excellent. So that's really impressive. Welcome, Grant. Tell us what you've got.
Thank you, Jeff. So my perspective here for this purpose is from the business side. So working with my enterprise clients, and whether they're SMEs or Fortune 50, they all basically have the same outlook. And this is what I've experienced, is that they want to honor these requests. They want to move these through their system with the least amount of friction. Their main concern is brand damage. They don't want the consumer to feel that somehow this business is being irresponsible with their data or not honoring their rights. So meeting consumer expectations it is universally a high goal, and what my clients are after. Companies have a couple of foundational things, and Ben touched on them very well. For an access or delete request, they have to verify the identity of the data subject, make sure that they're talking to the person whose data they're holding. When they have an authorized agent, this complexity goes up quite a bit, because we also have to verify the authority of the agent to make this request on behalf of the data subject. This becomes even more critical when the agent is actually asking for an access report. Right? So we have a third party asking for someone else's data to be sent to them. That is, so we have to verify the identity, we have to verify the authority, and we have to verify the extent of the authority that this agent is authorized to receive it. Within the enterprise environment, also, you have this issue of validating the data subject's data. So you may have 2 Susan Smiths in your system, or you may have 50 Sue Smiths in your system. Making sure that you're obtaining the correct data subject's data it is an important step. And often this will require company specific information, a member number, an account number. Maybe it's tied to a phone number for a grocer who's got that kind of loyalty system, or it uses their email, or it uses physical address. And so these aren't standardized, and they present a challenge for the privacy agent, because in their standardized request, they may not include the data point that the enterprise client needs in order to validate the data. And so they may be replying that even in a do not sell context, I've received your do not sell, but I need X, Y, or Z, or I've received your do not sell, but you need to go to this designated channel to exercise it because we've automated it with a web page. So what we've got, because this is a new and evolving area of the law, is companies' fresh take on what these requirements are. They can set their own channel. They can require a login through an account if the customer has an existing account, but they can't require creation of an account if there isn't one. So for those enterprises, especially that do not have password protected accounts, they have to make out of whole cloth a system for verifying the identity of the data subject, verifying the authority, and validating the data. These are tough lifts for some of my clients, and they're highly dependent on a company's individual tech stack and their capabilities and what their key data points in their systems are. I go about outlining these because at this point, what happens on a lot of enterprise clients that I have is they get to their email box 10, 20, 1,000 requests from an agent about the company's customers asking for do not sell or delete my data or do both, that haven't addressed these issues, haven't addressed satisfactorily identifying the data subject, showing the extent of the authority, and often, very critically, giving the information necessary for the company. Now, a company has the reciprocal obligation to list in its privacy notice everything that's required to exercise your rights. And they also have what I consider the do not ignore obligation from the regulations under CCPA to tell you when you've gone to the wrong spot. So some of Ben's slides, you'll see those enterprise clients are saying, you've gone to the wrong channel to make this request. It's not that they're denying it, and it's not necessarily that they're unaware of their obligation. It's that you've gone to the wrong channel by going to the easy to find privacy inbox. But the company does have an obligation to respond. But again, remember, the company's motivation is to meet its customers' expectations and not have them disappointed in the process. And that's why I advocate and have reached out in the past to, I would say, moderate success to these agents who are giving my clients hundreds and sometimes thousands of requests to open a dialogue about we need to have a process that handles the enterprise responsibilities, because of course, let's face it, the bottom line is if the enterprise fails to do their job right, they could end up with data breach liability, which is one clear and scary issue for an enterprise client, is a data breach caused by this. So we need to meet and confer, and I'm a big proponent for building a standardized approach that then we can offer up to legislators to adopt and give them a meaningful way forward so that we all can meet the consumer's expectation for exercising their privacy rights. So with that, I'll turn it back to Jeff.
That was excellent. Thank you, Grant. That insight's appreciated. Understanding the business perspective is really important here, because it's just amazing how fast this space is evolving, and these companies are under sort of an enormous pressure, I think, to get this right, and we need to recognize that. So let's get to our final speaker here. That is Craig Erickson of Privacy Portfolio. Craig is a consumer, but perhaps not just an ordinary consumer. He's also an IT auditor and a cybersecurity professional and a project manager. Welcome, Craig.
All right. Well, thank you very much. I'd like to share my screen with you. So here we go. So yes, I'm Craig Erickson. I'm a California consumer, and I decided to appeal to a couple of agents to help me exercise my privacy rights. What I wanted to know was, what can a privacy agent really do? And how would I know which one is best for me? But advance this. But yes, as Jeff said, I do have cybersecurity and auditing experience. So I use vendor risk tools and techniques just to manage my personal vendors. One of the things I did was conduct a CCPA compliance tests on 200 of my personal vendors to determine the amount of risk each contributes. So I do feel fortunate that I live in a state that does have a privacy law. I just had to really test it and find out how it really works, because, you know, every consumer is different. I have my own reasons for why I exercise my privacy rights. Actually, I exercise my privacy rights in the hopes that I can get leverage over some of my vendors. Now, how is that? Well, I mean, this may come as a shock to you, but not all my vendors resolve all my issues and respond to my inquiries. And when I can't talk to them, I get frustrated, you know, like a lot of other consumers do. So if my vendor gets breached, they get incapacitated due to a ransomware attack, then it's a real security threat to me. And I just want to have someone that I can contact in the event that things go sideways. Now, every vendor is different. I don't buy a lot of stuff, but I do consume a lot of information and services. And that's why I define, excuse me, as a vendor, any entity that I provide personal information to, because, you know, my goal is to govern the use of my personal data. Now, as a consumer, it's a pretty tall order to understand which law is relevant to my rights, and then how that law applies to each of my vendors before I actually know which right I'm entitled to. So here's an idea of how my CCPA rights pan out after applying them to my vendors. Well, I've got 200 vendors I start out with, but you take off the 62 that don't respond, and that leaves me with only 138 vendors that I can really work with. And out of that, there's going to be 32 that are exempt. So that leaves me with only 106 eligible vendors that my rights really apply to. And you know, I mean, there's no way that a consumer or their agent is really going to know this. So in some cases, maybe spray and pray is really the only way to find out. Now, I also want to add that if it weren't for the privacy professionals who are processing my requests, my opportunity ratio would go down to 0. So the way I see it is, you know, the glass is half full. So my CCPA tests are actually based on the statute and the regulations. I test mostly for adequate disclosure, identity verification, and qualifications of the personnel who respond to my requests. But I have a responsibility too as the consumer. And as a trained auditor, I try to get the best outcome by making every effort to be the model consumer. I have evidence of my relationships with these vendors. I have copies of all of the privacy policies in terms of service, evidence of all of the information exchanges between us. I even have a mechanism so companies can authenticate my identity as a California consumer. So that isn't all. I still have, after all that, I have to satisfy the legal definition of submitting a verifiable consumer request. And that's why I had to ask, is my vendor a data broker? And do they have a mechanism for authenticating agents? Because it makes a big difference in how you craft that request. Now, you can access, all of these, data sets, some of the evidence behind these studies through links in our handouts. But really what I want to show is how I applied this vendor risk methodology to how do I determine what privacy agent is actually best for me. Well, one way to assess vendor risk is, of course, the old questionnaire. And I came up with this one, which I did send to a couple of companies. I didn't ask them to return it because, I actually have more confidence in another tool that's been used by market research firms for decades, and that's mystery shopping. Now, I'm not the first one to do this mystery shopping. And the reason why I chose these two companies is because some of the IAPP members, the International Association for Privacy Professionals, they were expressing their concerns about Privacy Bee and mine, and they were trying to get people's advice. One member actually went to the trouble of taking screenshots so they could share how the services work with the other members. Another member actually did some pretty serious due diligence on, one of the company's owners using entity resolution techniques. And the reason why is because, put simply, trust is knowing who we're dealing with and to some extent what they're doing. So what we have here are the observations that I have from a consumer standpoint. I want to know, as a consumer, am I getting the service that was promised? And am I actually able to deal with my vendor to onboard, get help, and offboard? And that's really important. So I just want to leave you with this. But I also have activity logs, and these activity logs are done in a pretty standardized way, which you'll be able to download from the links. It allows me to quantify many aspects of vendor risk in a standardized and auditable way. And then I can use that information. What I did is I cobbled together a comparative analysis here of other agents so that I could see common trends and outliers. So what happens when consumers submit privacy requests? Well, usually we end up at a ticketing system, but sometimes we get lucky and we talk to privacy professionals who answer our questions and gladly help us exercise our rights. And that's why I published a data set just exclusively of the appropriate responses so that people could see some positive examples here. Finally, these are some of the actionable takeaways I do hope you'll consider. And that's listen to the voice of the consumer. Include consumers in UI testing, product development, QA, marketing, privacy and security awareness training. And I can help you test your privacy processes, or ask your friends and family for some real frank advice I think you'll value. Thank you.
Nice. Thank you, Craig. Some really good research there. Appreciate that. We've got a couple of questions from the audience. Let's go to those questions first before we go to some of the other questions that we put together for the panel. We've got one for Ben Moskowitz from Jacques. Are authorized agent services acting as consent receipts for verifiable credentials? Any response to that, Ben?
I think the answer to that is no. There aren't too many authorized agents that are really functioning at scale yet. I mean, we talked about the two big ones, and they both actually kind of fall a bit short of the definition of an authorized agent, I think. Privacy Bee is basically an authorized agent, but my understanding is that they're not collecting like a valid power of attorney. So there's that. Mine, I don't think is an agent by a strict definition, because what mine provides to the consumer is an interface in their own mailbox where, strictly speaking, the requests are coming directly from the consumer, and mine is just facilitating that. And so I think the answer to the question is no, not really. But if we're looking to the future, maybe we can unpack that question, in a different setting.
Yeah, I think that's interesting. I was actually looking at doing something similar in a different space, and I actually thought getting a greater level of consent might actually be interesting, becoming more of an authorized agent. Yeah, that's interesting.
Well, what I find interesting is that a lot of the consent managers or the DSAR solutions that enterprises bring on are actually in a great position to become authorized agents, because they're already on one side of these transactions, and they understand how to manage identity and consent at a different level, I think. And so if OneTrust or Ethica or Wirewheel, if any of those companies wanted to move into this more consumer-facing B2C space, I think that they would be in a good position. Naturally, that creates some tension, because if you're a B2B company, your duty is to keep the inflow manageable. And so I think that they're not likely to do that anytime soon for that reason. But it's interesting to speculate about how the ecosystem could evolve.
Yeah, well, that is a question. We have another one, but let's continue along this line for a second. Where do we actually see, let's open this to the broader panel, right? Where do we see the future of privacy agents going? You touched on it a little bit, Ben, right? But, is there an opportunity for a third party, whether it's some of the DSAR companies or a different third party, to provide some sort of a different layer of identity verification, or maybe other services that could bridge this gap that we're seeing now?
So from my perspective, the interesting thing when you're having to handle like the privacy offices in email inboxes, of course, that's a fun place to wade into in general. But when you get these emails from someone standing in the position as a third party, they're not always, as Ben is portrayed, they're not always actually acting as a third party, as an authorized agent. They might be acting more as a facilitator to assist the consumer in making the request. And so it's really the consumer who's making the request, and it's the consumer who's asking for the action, versus a third party, a true power of attorney, saying on behalf of my agent, or on behalf of my principal, I'm making this request to you to take this action. So there's kind of a broad spectrum and approach here. You could have I could see where we could get to standardized APIs. We could get to tokenized identity systems. Certainly, as Ben has indicated, someone like, Wirewheel may be uniquely situated with the technological prowess to be able to come into an enterprise and convince them that this tokenized system is an adequate showing of identity, because that's a big friction point for companies that don't have online login, is making sure you have the correct data subject. And then an API could also ask for the additional information necessary to validate. So we could have a way of standardizing this, and that agents could still have a role, an important role of collecting the consumers, setting appropriate expectations, and then interacting with enterprise and working together collectively to improve the ecosystem for the benefit of everyone. I mean, agents can, provide a valuable service that people want to pay for. Companies can meet their consumers' expectations for being transparent and responsive, and consumers can get the information they're entitled to under the law. That, I think, is our end goal. Right now, we have this ad hoc system where no one is happy.
Agreed. That's really interesting.
So I would just chime in and add that from a consumer perspective, what the consumer needs is more incentive to even use these services. And even though privacy rights is popular, I don't think that that's popular enough. I think that when it comes to consumers managing all of their vendor accounts and online accounts, and every time they move and change their information, that agents could actually provide a better service. Agents could actually have purchasing power and be a signer on someone's checking account. You could eventually say to someone that, a vendor that has a problem or someone that's trying to sell you something, hey, go talk to my agent.
Right. And Jacques has just added an additional question aimed toward Craig, but I think this sort of ties into the same question. Can consumers use perhaps a digital wallet to transact with these agents? It seems to me that could actually tie into, a sort of an API type service as well, to verify identity, whether that was Wirewheel or some other sort of third party, right?
I do think that's possible. I think that in this API kind of, construct that we have, one of the things that we want to do, because I used to do business process integration a long time ago with different standards, and everybody, we're still back to that same problem. Everyone wants to have their own proprietary system. Even, Ben mentioned that there's all of these different initiatives that have the same goals, but everyone starts up their own. So I think that whatever we come up with has to be kind of plug and play, so that we have room for other businesses to participate in that, and that it's really open.
Yeah. Can I build on that? I worked for many years at Mozilla, which is a great open source company. It makes the Firefox web browser. And so I see this authorized agent thing through this lens of the user agent, and just think about a web browser. A web browser takes care of a lot of abstractions for you to be able to surf the web and just, decide where you want to go. You don't have to think about HTTP. You don't have to think about certificates. You just have to think. And you can set privacy settings in your browser, and you can save passwords in your browser. And the browser is a great user agent. When I think about authorized agents, it's almost like a emerging category. There's not great examples yet, but the authorized agent ought to be your consent manager or your intent manager, or however you want to think about it. And the role that data rights play in all this is that we've gained these very important 21st century, foundational rights, which we didn't have before. But it's as if we gained the right to connect, but didn't have HTTP and didn't have web browsers. So we only have the primitives here. And I think that the path forward is defining, some of the next building blocks. And the companies that are the most well-positioned to really drive that, they are the DSAR providers. They are the Ethicas, Wirewheels, OneTrusts. And that's because, if you just take, I think, OneTrust, I checked about a year ago, OneTrust alone, I think, accounts for half of the Fortune 500. if OneTrust agrees to implement a relatively standard API, you've got half of the Fortune 500 who can be responsive to these requests in a pretty consistent way. I think if you were to add, the top 5 DSAR providers, you'd be even higher. And so that's kind of what we're interested in working on. And in that vein, it shouldn't really be the responsibility of the data protection officer and the small or medium-sized enterprise to worry about this stuff. I think they should be able to benefit from the open source and open standards that ultimately grow up around all this, and then benefit from having a little bit more certainty overall.
Absolutely, that's really interesting. I think this ties into the question we haven't addressed yet from Tim Bell here. It's a little bit long, and he's actually asking about privacy agents that request that you don't contact their consumers, right? And maybe they send you limited information, say don't contact my consumer directly, and so how can you listen to those requests, and how can you actually verify that these agents actually have the right information? Grant, you addressed this question, I think, pretty well in your presentation, but we talked offline yesterday about this a little bit, and I think you had an interesting point about sort of bifurcating or trifurcating some of those questions about how maybe companies can respond a little bit differently to do not sell requests versus identity verification and access requests. Maybe you could expand on that a little bit.
Sure. So the experience that I'm seeing on the inside is that do not sell is the hot seller. Right? Everybody wants do not sell. Do not sell is the thing that's probably the most offensive to consumers, and the thing that they don't expect, and is really driving a lot of the requests. So, on the order of 10 to 1 kind of popularity, much more popular. And the do not sell, of course, doesn't have any identity verification requirements, so it should be much less frictionless. The issue that I see mainly for my clients are getting the appropriate validation data element. And if it doesn't come, it's an issue. So what I often encourage my clients to do is set up a web form where the customer can simply input the name and whatever additional data element they need in order to make sure that they've got the right data subject, and push submit and take it in. And it doesn't matter if it comes from an agent or not. They have the right to verify the authority of the agent, but for most of my clients, it's more effort than certainly it's worth to go into verifying the authority of the agent to make a do not sell request. Just process the do not sell. Often our issue is if they say this is Sue Smith and don't sell my information, my client may have 5 Sue Smiths. So that becomes their question. Do they opt them all out when 4 of them haven't made that request and they're taking a data action that's not been requested? Or do they go back? So we have the do not ignore response and we return back. For access and delete, it's a whole different ballgame. And we do have this ID verification issue, and it really it really clouds it. So clients are having to make a decision, like on a delete request, which is again more popular than the access requests as I'm seeing. How much do they want to dive into the agent's authorization once they have all of the information necessary to verify the data subject's identity? If you have the login credentials, the password and the user ID, and you can get into someone's account and push the delete button, are we even asking the question about whether you're an authorized agent to make the request? So there's a lot of this that's kind of greenfield in front of us, and a lot of it that this kind of discussion that we're having here could serve, I believe, to everyone's benefit, because we're spending a lot of time and effort to do kind of risk analysis and try and get these right. Without a lot of guidance or industry common understanding.
Absolutely. I think that's a fair summation. we've got a lot of additional questions we could ask now, but I think we're sort of finishing up here. Why don't we actually give each of you guys an opportunity to sum up any final words that you've got? Anything from you, Ben?
Yeah, what we've heard is that the regulatory framework and the best practices are not there for anybody to have a satisfying experience doing this yet. If you're a consumer, it's hard to do. If you're an agent, there's no instruction manual. If you are a company, you're receiving a ton of arguably spam that's not well directed, and it's hard for you to, and time consuming and expensive for you to process. So we had to find a way to improve everyone's experience. The thing that we can't negotiate on is, the sanctity of these rights. It cannot be overstated what a big deal it is that individuals have agency and control over their data legally in at least 3 US states now, and probably many more to come. That's a really big deal. And, you'll have to forgive me for constantly bringing in the analogies, but I think another good analogy is this is almost like the beginning of emissions standards. In the 70s in California, you had the nation's first emission standards, and the automakers weren't very happy. It drove up the cost of making cars. It created a lot of new bureaucracy. It was painful, it was expensive, but it was important because we needed to have good air quality and we needed to get ahead of that. And as California went, so went the nation. Today, this is just table stakes. This is a baseline, along with so many other consumer and environmental protections that we take for granted today. So data rights, I think, are very similar. We're in the kind of pain period right now. It is creating cost, it is creating uncertainty, but we have to find a way to get through it because we're all individually consumers and we're all going to benefit from having these rights. It's going to increase our power in the marketplace. So my message to everyone who's struggling with the overflowing inboxes is, if you'd like to get involved in a dialogue about how we can, push things forward, we'd love to be in touch. Sure, we'll be in touch after this webinar with other things to get involved in, but thanks for having us and listening to us today.
Great. Thank you, Ben. Craig, any final thoughts from you?
Well, I just want to expand on one of the points that Ben brought up about, not knowing whether your request is fulfilled. So let's take it on a larger level. Sometimes people want to know whether the law is being enforced. And so knowing from the enforcement agency that they're doing their job, that could go a long way in just helping to assure that, consumers that something actually is being done. And it was just yesterday that the Office of Attorney General for California actually posted a lot of the progress they made in terms of the enforcement actions they've taken. I've included the link to that in our handouts. And so it's just great and refreshing to see that, yes, the law is being enforced. And so that makes it worthwhile, in my opinion.
Yep. And I just posted that to the chat for anybody that's looking for it. That link to Craig's summarized information, and that link to the Attorney General information is in that link. Okay, and Grant, let's give you the final word.
Sure.
What do you got for us?
I really appreciate the forum. I think this is the beginning of the discussion that we're having. We're certainly gathering the evidence and seeing the friction points. I'd love to continue this discussion with Privacy Bee and mine and Wirewheel and OneTrust, have the other players in the ecosystem participate in this discussion. I think everyone benefits from gaining a common understanding of this. All of us are after the same goal, which is that the consumer's expectations and understanding are met. I know from my client's perspective, retaining their customers' trust is a premium value for them. And that trust is, part of it is, what is the consumer expecting is done with their data? So are they transparent? Are they responsive? And that's where I think working with the agents, working with the DSAR providers in order to build kind of a common understanding and a common pathway so that we can offer up to legislators who seem to be hungry for passing privacy legislation, but everyone seems to want to draft it a little bit differently, which will keep me fully employed for many years to come.
Absolutely, absolutely. Well, thank you everyone for attending. This has been really wonderful from my perspective. Karen, do we have any wrap up that we need to do?
Only if I unmute myself.
Okay.
So basically, I do want to thank our panelists. That was a terrific session. And to your point earlier that you've all made, actually, is that this is the beginning of the discussion. And we'll continue to have webinars like this to try to dive deep into subjects or topics that we feel need some exposure and some daylight. So with that, I will close out and thank you all for attending. The session will be available online later. Thank you so much.
Thank you.
Take care.